On the air with FLA Law on the radio. Thank you for joining us. Hopefully, you are always watching or listening at 5 every Tuesday. As you know, we are the personal injury attorneys of Perenich, Caulfield, Avril Noyes, and we bring to you this live legal call-in talk show every Tuesday at 5. So now's the time to share with your friends and family. Let them know that FLA Law is on the air, and we are ready to talk to you about some legal issues tonight. And of course, take any questions that you might have as they come in. I have a wonderful special guest with me tonight. As you know, sometimes we bring in very well-known and decorated members of our community who are able to talk to you about other areas of law than what we deal with. You know that Perenich, Caulfield, Avril Noyes is an injury firm, and we handle all kinds of personal injury matters. But there are so many other legal issues and legal areas of law that people encounter all throughout their life, and we learn about them in law school, but we like to bring in the specialists who know more about it than we do, so that you and the community and our listeners can be well informed. And also you have a resource in the future if you ever need resources or an attorney in other areas. This show can hopefully introduce you to those lawyers and who to call, and hopefully someone that can help you with your case in the future. With that being said, the topic for tonight is really going to be all about landlord-tenant law, and we have a wonderful attorney here with us for that. And I'm going to, of course, reintroduce her to some and introduce her to others because she has been a guest with us before in the past, and she graciously came back and allowed me to re-interview her again tonight. So I'm so happy that she's here with us. But before we jump into that and letting you know who she is and allowing her to introduce herself, I want you all to know how to tune in and continue to listen. If you're getting out of the car, you can't stay on the radio, you want to watch the live stream, we've got two ways you can do that. So hopefully you're tuned in on the radio and you can tell everyone to turn, obviously on the radio at 106.1 FM or AM 1340. However, if you're wanting to watch the live stream in the studio, we are live here at WTAN. That you can do on Facebook and YouTube. So the best way to find that is if you search our firm name, Perenich, Caulfield, Avril Noyes Injury Lawyers, and you type that into your search bar, either on Facebook or YouTube, you should be able to find our live feed right now. We are live. You can ask your questions or comments in the chat section or in the comment section. If you don't want to call in, but you'd rather just leave a comment or a question for us, you can do that on the comment section as well. I'll read those out, and me and my guests will, of course, just talk about them on the air or try to give you some resources and point you in the right direction if it's something that we don't necessarily handle. With that being said, you can call in tonight. We do have the lines open if you would like. The best way to call in is directly to the studio at 727-441-3000. Again, the call-in number, if you'd like to call in and talk to us tonight, is 727-441-3000. That, of course, will get you right here into the studio, and we can discuss whatever your issues or questions the question that you might have are. And without further ado, as I said, I'll reintroduce to some and introduce to others. My special guest tonight is Sanatosha Sawar. She is the owner and founder of Sawar Legal. And she was our guest, I want to say, we were just talking about it off the air, I want to say a little over a year ago. She came in and joined us to talk a little bit about her mediation practice. She's actually a certified mediator in the state of Florida. And so we talked all about mediation and the benefits of mediation and what mediation really entails. But if you remember, you would also know that she also has her own law practice, and she handles cases as well, on her own that are not, just her mediation business. So we're here to talk about some of that tonight. And although she wears many, many hats, landlord-tenant is what we're going to focus on this evening. So, Sanatosha, please introduce yourself and tell our audience a little bit about you.
Thank you for having me, Jackie.
Absolutely.
Good evening, everyone. My name is Sanatosha Sewar. I am the owner of Sewar Legal PA. It's located in the heart of downtown Clearwater. At Sewar Legal, we do practice civil litigation. However, our primary focus is real estate law.
Yes.
So that means we practice in the areas of landlord-tenant, construction liens, breach of contract, and also probate matters.
Yeah.
And then I also have my mediation practice where I help these same types of clients find solutions to the issues without, dealing with the prolonged court battle. So, yeah.
And as an aside, I recently went through a mediation through small claims not that long ago. I was helping a staff member of ours with a matter, and the mediator I thought was great. He did a great job with small claims. I'm like, I haven't been in small claims in years, but you made this mediation process pretty smooth. So it made me think about you when I went through that. I was like, I wonder if Sanatosha is doing these still.
Well, small claims, the mediations are during court or right after. So
it was like in lieu of the pretrial, they send us straight to the mediation. So
it's always a good option.
Yeah. So okay, great. So you mainly do kind of the landlord-tenant real estate world, and you said you're located in Clearwater. So when you were talking, that obviously piqued my interest when you mentioned construction liens and landlord-tenant, because I feel like that is kind of on the forefront of a lot of people's minds right now after this area has gone through what it's gone through. In October, we came out of back-to-back hurricanes, which I didn't ask you, but I know a lot of people were pretty severely impacted, especially those that live along the coastline. One of my partners, had almost 3 feet of water in his home. And so people are really still trying to get out from under a lot of that, impact as far as the storms, and the people that own the homes are now going through the hassle and the headache of trying to fix them. I know even my own parents have a rental property that a tree fell on, and so the roof had some really extensive damage, needs to be repaired. FEMA helped to some degree, but obviously didn't cover everything. And then you have renters who, are renting, and their home, at some point or all of a sudden becomes uninhabitable.
Right.
I saw people on the news where they literally was like, you can't come back. You find a new place to live. And I'm like, wow. And, me being a personal injury attorney, I don't necessarily always know exactly what rights these people may have or what the circumstances end up being. But I do know a lot of people are still displaced. And I recently saw, and I don't know how true it is, but I saw something about the FEMA vouchers are being canceled or they're expiring. I don't know the basis behind it, but they're not extending them as long as I guess people expected. And so people are, on these FEMA vouchers, and they're living in hotels still. And a lot of them are actually coming to an end, I guess, prematurely or sooner than they would have thought. So with that being said, you still have a lot of people displaced.
Oh, yeah.
And a lot of them are renters, and a lot of them also are landlords who are trying to figure out what to do with the properties. So with that being said, when you've got properties that have been destroyed or now they're uninhabitable, and you've got renters who they have a lease, like this is an agreement that, we came up with, and now you're telling me I can't live here anymore. I just feel like this is a big mess for the landlord-tenant world, right?
Yes.
So I feel like that just creates so many legal issues, and I'm sure people are trying to figure out, where do I stand and what rights do I have? So with that being said, when you have these issues on both sides, do you mainly represent tenants, or do you represent landlords, or do you help both?
In the beginning of my legal career, because I had experience being a tenant, I felt that it was just easier to understand the tenant's perspective and the importance of living comfortably and enjoying where you live. So naturally, I was ready to represent the tenants, But then
fight for the rights of the people.
Of course. Well, over the years, gaining experience from representing tenants and becoming a landlord myself, it helped me to realize that providing guidance to landlords would be beneficial for both parties. So I did add landlord representation to my practice. And right now I do primarily represent landlords. But making the shift over to representing landlords, it allows me to guide the landlord and always making sure that the tenant has a decent place to stay. The maintenance requests are being handled in a reasonable, timely manner. And also that communication is open. I do believe that the landlord sets the tone, and the foundation of the relationship. And when you have a good foundation, laid in that type of situation, the landlord is also in the prime position to protect their investment. Because, property is expensive.
Yeah, exactly.
So,
and it's harder to appreciate that from the tenant side sometimes.
Exactly. And I definitely appreciate it now. So, yes. So it just allows me to help both the landlords and the tenants while also keeping the relationship fair and professional between the parties.
So then what are some of the most common disputes that you see that are kind of arising between landlords and tenants? Like if I had to say, give me your top issues that are coming up in your practice, what would you say those would be?
So the top issues, there's three main top issues. So repairs and maintenance.
Yep, I could see that.
Rent and fees. And then you have, of course, the return of the deposit after you leave.
Got it.
So those are definitely the top three that I see all the time.
Okay. And so then what kind of, approach would you recommend to resolving these kind of issues that are coming up then?
So, of course, there's a little caveat, it depends. That's always the answer.
That's the lawyer answer.
Of course. But just to say that all of these issues can be tricky. None of them are ever just cut and dry. So what I'll do is give my best answer without making it a legal lecture, So for repairs and maintenance on the tenant side, the important part is to communicate the repairs promptly. So definitely notify your landlord in writing, not over the phone. I know it's easy for us to pick up the phone and say, hey, but I think that it's very important to keep everything in writing when you need repairs. Definitely. And also keep a dated record. So just so that and so that you would be able to present if needed when you reported it, when they responded, did they actually do? Did it get resolved? You'll have a dated record. And then for the landlords, cold in here. For the landlords, responding to that maintenance request.
Don't ignore the work orders.
Do not ignore the work request, So responding in a reasonable time. If the repair, it may take longer than you anticipated. Communicate that with your tenant, It just keeps a lot of confusion down, a lot of misunderstandings down. And then also keep them updated in writing instead of calling them, And then keep your own dated record for what I would recommend. A lot of the landlords that I come in contact with, they have multiple tenants. So I don't recommend text message. A lot of landlords like to do it.
Well, that's in writing.
It is in writing, but I think it creates an informal relationship with your tenant, and I think it definitely should remain formal. Just business, And then, so I would highly recommend having something like a portal or at least email. At least. So then the next issue is rents and fees.
Oh boy.
With the tenant, the main concern is the increases, the increases in fees or the increases in rent. And then, of course, fees that might not be, they might not be aware.
Yeah. Things come up,
fees.
I would imagine, like through a tenancy that may not have been in the beginning. Like you can't itemize every single possible fee or expense that might come up when you sign a lease. So I think you're right. If things come up throughout the term of the lease, you have to notify them properly, right?
Yes, you definitely have to notify them. But just for the people who are out there that don't know, Florida does not have rent control.
Okay.
So it is.
This is in New York.
So it is a standard for the landlords to follow market trends.
Okay.
So they're usually just trending with the properties that are around you. But of course, other people go up, the landlords go up. So that's been a thing.
Which I think we've seen a lot, sadly, in this particular market. I feel like in Pinellas County, I heard a lot about the rents are obviously just continuing to go up, which is forcing a lot of people to go into other counties like Pasco and Hillsborough, because the rent, I don't know if I call it a rental crisis, but the rental prices are just really, really high in Pinellas.
Yes. So, just to be aware of it, I highly suggest that the tenant reads their entire lease. I've been that tenant before, so don't feel bad if you haven't read your lease and you're in a lease. Just go do it now. Go find your lease and read it.
As an attorney, I will definitely admit that I don't always read the fine print.
Yeah, and so just so you'll be aware of the rent amount, and then of course the fees. There's been some leases that I've read before, and then there's like hidden fees. Just in places that you wouldn't expect a fee to be. Right. So just read over it, take your time and read over it. And then, of course, just ask questions, if you don't understand something.
Right.
And, of course, that goes for the pet fees, the utility fees, amenities fees.
Yeah.
Fees.
Now, that's actually a good question. So would you recommend, maybe it's a very expensive property or a high value lease, that people get attorneys to read their leases before they sign them, or would that be just an unnecessary extra expense?
It will probably be an expense, but I would suggest that when you get your lease, read it yourself. If you don't understand it, ask your landlord, especially while you guys are on good terms. Yeah. They might be, I'm pretty well, I won't say I'm pretty sure, I don't know everyone, but it seems like they would be more amicable to explain to you what certain things mean, so you guys can be on the same page. So I would say read over it yourself, ask someone you trust, or
look for the fees.
Ask your landlord. And then if you feel that you put yourself in a position that you really just don't understand, definitely call.
Then call an attorney.
Yeah,
and do
definitely
a
call an attorney. Yeah. Oh, yeah.
We do have one comment on Facebook that says rental increases across Florida is rising. Orlando is having the same issue. Yeah, I think it's a statewide thing for sure. With our rental market, unfortunately. It's just, Florida's is an expensive place to live nowadays.
Yeah, it is. Yeah. So from the landlord's perspective, it is important to be clear with any expectations surrounding the payment of money. And that goes for the amounts, the due dates, the late fees, the increases, the notices, just be clear so everyone's on the same page. And also be precise and follow the required timelines because some landlords, they just don't know that the Florida statute set certain timelines. So just go and review Chapter 83.
Because I remember hearing, and I don't remember where in my legal career I picked up this information, and I hope it's not false, but I remember hearing that even if there is a lease agreement, and you can correct me, but if a landlord allows certain things to occur, like, for example, the lease says that their rent is due on the 3rd, but this person notoriously always pays on the 12th, and they've accepted it always on the 12th. does that somehow then become acceptable because they've been acquiescing or allowing that behavior to occur?
You have effectively amended your lease agreement.
That's what I thought.
So don't do that. I always tell my landlords, stick to your word. You know, don't, unless you're okay with changing it to the 5th. You know, if you're okay with that, change it and leave it. Don't go. You can't go back.
Flip flopping.
Yeah, you can't go back.
Try to enforce it when you've now are effectively amended it, like you said.
Especially, you know, I can go into a whole thing about that. But yes, stick to what your lease terms say. Or, you know, if you decide, okay, I'm okay if they get a few extra days. Just put that in writing. You know, just so you're not fighting.
Like a grace period.
Yes.
Make it a written one.
A written grace period. And then the last thing is a return of the deposit.
Yes. I had an issue like this in law school. I don't remember what we were fighting about. My landlord wanted to keep a portion of my deposit for the carpet, like the cleaning of the carpet. I'm like, that's normal wear and tear. Give me my money. Like, you guys clean the carpet. That's not my fault.
Sometimes they might put a term in there that says carpet cleaning, $300.
If I remember correctly, obviously it's been like 14 years, but it was like nothing explicit. So that's why I was like, this is normal wear and tear. If you guys wanted to keep the carpets clean, you should have been coming in and maintaining that yourself. So, and they actually did give me my full deposit back.
Fight for your rights.
Yes. Look, you know how we were straight out of law school. We thought we were really serious. We really knew something. So I wanted to put my legal prowess to work it, and it worked for like a $500 deposit or something small.
Hey.
So let's talk about the deposit, because I know that can be a thing, right?
Yes. So for the deposit, it's important for the tenants to know that the landlord has to return your deposit within 15 days of the lease termination, or 30 days if they decide to claim an amount off of the deposit. Right. So what I always suggest, and I would have probably suggested it to you too, take pictures when you move in and when you move out. Right. Everybody takes pictures moving out, but they forget to take the pictures in the beginning in.
When they do their kind of checklist. Because I know some places will give you like a checklist to go throughout and do yourself. That's the perfect time to take pictures, I think, because it's empty. You haven't moved in yet. You know, everything is visible.
Right.
And you can take your pictures.
Yeah. And I think that's what everyone should do. Every tenant should take pictures before moving in, because sometimes the landlord might think you broke this, you know, and then it was already like that when you moved in.
And document it. So if you're going to report, like you said, make sure it's in writing. Because I think I remember having a personal injury case, where a client's child ended up being injured by a faulty closet door, and the door was always coming off the track, and they had reported it initially in their move-in checklist, but they didn't do a written work order. But they did, thank God, put a little bit of a note on that move-in checklist that said broken closet. And that helped us, because initially the landlord was arguing that they had no notice, that they never knew that the closet was a problem, and it ended up falling on the little girl and amputating part of her finger.
Oh my goodness.
Yeah. And so they, of course, were kind of putting the finger back on the parents, saying, well, you guys never told us that this was a problem. And they swore to me that, yes, we did. We reported it multiple times. Well, how did you report it? Well, we called the what do they call it? The lease agent, the leasing office. And we told them multiple times. They said, oh, we'll send out, maintenance, yada, yada, yada. But that was all verbal. It was always by phone. And fortunately, we found the initial walkthrough checklist, and it did, sure enough, say broken closet on it. So that kind of kept the case going. We were able to get it resolved. But even people don't even think about it in that type of a vein. But even in that type of an avenue, it can be helpful to document everything.
Yes.
In writing. Don't just call the leasing office.
Yes. Don't just call. Please write it down. It helps us as attorneys,
Yes.
to be able to represent you properly if you just get it in writing. Even if you follow up the call with an email to say,
Bingo. Yeah.
hey, I just left the office. Even if it sounds redundant that you're saying exactly what you just talked about, just put it in writing.
Yep.
The landlord side.
Yes.
All right. So with the landlord, I always let them know that they need to place that deposit or advance rent
It's supposed to be in a special
separate account.
Yeah. Look at me remembering the statute.
Yes. Do not commingle that money with your personal funds.
It's supposed to be an interest-bearing account or no?
It doesn't have to be.
Doesn't have to be. Okay.
But if it is, you're supposed to inform the tenant that it is interest bearing. And then, of course, provide the tenants with written notice of the account details because they're supposed to know if it's interest bearing or not. And an itemized list of what you are subtracting from the deposit. It can't just be an amount. It has to be specific.
What it's for, each line item. Yeah.
Yes. And then again, you have the 15 days to return the deposit or 30 days if you are putting a claim on the deposit.
Yeah.
And then also for the tenants, if you do not agree with what the landlord is subtracting from your deposit, it is very important to object in writing. Do not call them. Put it in writing.
Doesn't the statute, does it say exactly like the manner in which it has to come out? Is it something, and I could be wrong, I feel like it had to be certified, or am I wrong about that? Or is it just written?
The good thing that I love about Florida Statutes Chapter 83 is that they do spell out a lot of that stuff.
It's very, very explicit.
Yeah, they tell you exactly how to handle it. So a lot of times, and I've gotten it from colleagues that I give out too much information. But if you go to Florida Statutes Chapter 83, it will probably answer the majority of the questions that you're calling me and paying me to answer for you. If you just take the time, Control F,
and find the words
find
you're
what you
for.
need, and just kind of read over it. And then if you're still confused, then call.
Yeah, and that's the beauty of our legal training. A lot of the language and the statutes are just not just normal things that people understand, and that you just don't have the background or the understanding of what the statutes may mean. So a lot of times you can try, but ultimately you may end up having to call Senator anyway, even after reviewing the statute. That's what we're here for. So yeah, so that's a good advice on that. Was there anything else for landlords on the return of the deposit, or did that cover it? I know I kind of cut you off with the.
I'm pretty sure I can go deep with both, but I think that was it.
I covered it.
Yeah, okay. I think. Yeah, as long as you
put everything in writing, that is the key.
That is the key.
Before we take a quick commercial break, I think that would be my number one takeaway from what she said so far. Everything you do communication-wise, I think on both sides for landlord and tenant, put everything in writing. Keep it professional. Try to avoid text, right?
Yeah.
But make sure that you're also complying with that statute. So far, such great advice for the landlords and the tenants that are out there listening. The lines are open if you have any questions or comments like we got on Facebook. If you just want to chime into the conversation, we're happy to hear from you. The number again is 727-441-3000. Again, we're streaming live on Facebook and YouTube as well with Sanatosha Sawar. And we will be back after this short break, and we will continue the conversation about landlord-tenant law in the state of Florida.
This is the Tan Talk Radio Network.
After a car accident, there are many questions that you need answers to. Who pays for my car repairs? Who pays for the medical bills? What about my lost wages? And more. The personal injury law firm of Perenich, Caulfield, Avril Noyes has been answering these questions for their clients for nearly 70 years. Since 1955, they've been a voice of the injured in the legal system. As one of the longest established law firms in Tampa Bay, Perenich, Caulfield, Avril Noyes is here to answer your questions. Listen to their live call-in radio show on this channel every Tuesday evening from 5 to 6 p.m. or call them at 727-796-8282 or visit them at voiceoftheinjured.com. Offices Clearwater, non-attorney spokesperson.
This is the Tan Talk Radio Network.
And we're back. Hopefully you have been tuned in to FLA Law live on the radio. If you have been, then you know we are here with attorney Sanatosha Sewar, who has been giving us all the rundown on landlord-tenant law in the state of Florida. So hopefully you've been getting some good information thus far. We, of course, are going to continue the conversation, especially because it's so timely, in my opinion, because of the number of landlord-tenant issues that are going on right now as a result of the storms that we had with Helene and Milton. And there's so many people that are still displaced from the storms that, unfortunately, in my little cosmo of a world, you kind of forget about the fact that people are still struggling with finding a place, getting their properties back to being, inhabitable, getting the contracting work done. And so there's so many different issues that come along with that. And so as I was thinking about that, I was considering the fact that what are people doing when, the units that they were renting, are not necessarily livable? Are renters able to withhold rent in those kinds of circumstances? Can landlords just kick the people out and say, sorry, I got to fix the place up. You've got to go. I mean, there seem like so many different issues, and I'm sure there's got to be legal, precedent about what happens in situations like this.
So when situations like this come up, it's important to know and remember that the Florida statutes provides non-waivable rights.
Okay.
Also for the landlord and tenant. So you cannot contract out of these things.
Okay.
Emergencies do not exclude these things.
No.
So I do have a short list. There's more, but I will just mention.
Kind of hit the high points.
Just hit the high points, especially in regards to how it affects you during emergencies or hurricanes or storms. Yeah. So I'll start with the tenants. The first right is to a habitable premises.
Absolutely.
That's number one. Landlords are required to maintain the property in a condition that meets the basic health and safety standards. So, of course, that's functional plumbing, running water and working locks, things like that.
So if the house is flooded out and there's no running water and there's a hole in the roof, things like that, that's not inhabitable.
Exactly. This duty cannot be waived. I'm pretty sure there are some nice tenants out there that might feel that, oh no, I'll take care of it because I don't have anywhere to go.
They'd rather just stay in their home, but it's like, no, you can't live here.
I mean, they can help, but the ultimate responsibility is on the landlord. The next one is the right to advance notice of lease termination. So even if it is a situation where just say it is uninhabitable and the landlord cannot just come along and say get out.
Okay.
They've
got to give them some time.
The Florida law requires it.
Does the statute say how much time generally?
So that depends on the type of lease.
Okay.
Because, we have a year to year, week to week, quarter to quarter. So the timelines are different.
Gotcha.
So you have to go and look at that for that.
Yeah.
Okay.
So I wonder, that's why I was wondering if a lot of what I was seeing in the news was legal or not. So I'm sure people have been calling lawyers about it, and maybe it's died down now, but I feel like I was seeing situations like where entire apartment complexes were like being condemned, and the fire department was coming in and saying, putting notices on the doors, and people are like, we have to get out like now. I wonder if that like supersedes the notice that the landlord would give.
Because it's not the landlord doing it. That
At
would be
that
the
point.
city.
Yeah.
That would be the city condemning. So that would be different. That would be different. But as far as the landlord coming along and saying get out, it has to be proper.
The proper notice.
And that rolls right into the next one. The next point I was going to make is that the tenant has the right to due process for eviction. So a landlord cannot force a tenant to waive their right to the proper eviction procedures. Self-help evictions, they cannot do that. Changing the locks, cutting off utilities, things like that, they can't do to make them get out. And the Florida law requires landlords to follow all the processes for properly evicting tenants. And then, of course, the last one is the right to that security deposit.
We can't forget that.
Well, the reason why is because, now is damages everywhere. So
who caused that damage? Right.
Who caused the damage?
These are like acts of God, right?
Yeah. These are acts of God. So you have to be, again, very specific as to what you are claiming on the security deposit and, how much, and it has to be correct. And then, the tenant has rights. The landlord just has to handle that security deposit according to the Florida statutes. They have to provide notice of the location and return it within the specific timelines. So those are the non-waivable tenants' rights. Now, on the other hand, the landlord has non-waivable rights as well. The right to receive rent. So, of course, there would be an issue there.
Because if it's uninhabitable, that right to receive rent feels like it would go right out the window.
So the issue that I was having,
if you can't hold up your unwaivable right, then I can't hold up mine.
Well, I think in the situations that I've been dealing with, communication is the key. Because a lot of people have been dealing with this situation, and it's new. Like this
literally
storm, both of them, just it really damaged a lot of people's lives. So I've seen where landlords said, hey, I have somewhere else to put you that's still habitable,
That's what I was thinking. I was like, well, do they have a duty to do that, though? If to provide alternative, housing for people?
It's
it's more of a courtesy than a requirement.
I would think a courtesy more than a requirement. I would say any reasonable situation, if you have another place for your tenant to stay, you would at least offer. It's not mandatory that they have to stay there, especially if that's not what they wanted to rent. But I think in these situations, the top choices would be, I have somewhere else you could stay, or we can do some type of rent abatement, or termination of the lease. So, but I think that all the parties have to be open to talk about those choices. You can't just say,
it's not a unilateral
I have another
decision.
place, you're gonna live over here because you can't do that.
Gotcha.
So, this is a situation where a lot of people haven't dealt with before. So I think, the foundation of it is just communication and working it out, with the other party. The next thing is the right to access the property.
Yes.
Some people, they don't want their landlords coming in.
But you need to let me know if you're going to come up in my house.
And so the tenant should know that as long as the landlord is coming in for repair inspections or just anything emergency, even to show a prospective tenant, like, the lease is coming up, they do have to allow the landlord in. But the landlord has to give about 12 hours notice. They can't just come in randomly.
Show up,
it has to be within a reasonable time during the day, too. You can't come at 6
hours of the
night. Or at night. And then another one is the right to enforce the lease terms. So the tenant cannot nullify valid lease terms. They can't say, oh, the house is messed up, I can bring my pets now.
That doesn't apply to me anymore.
Or subletting just because there's been an emergency, stuff like that they can't do. And then the last one I'll give is the landlord cannot be forced to waive their rights to seek damages that the tenant caused.
Yeah.
So that's just a few, but of course, if you go to Florida Statutes 83, it'll give you more
Exactly.
that apply that are not waivable.
Is that what they call like the landlord or the tenant bill of rights or something like that? Is that how people call it? That
they put it in a
Yeah.
tenant bill of rights.
I think I've heard of that term being used that way. But yeah, I think that's obviously a trouble on a lot of landlords' hands right now when you've got two storms and you've got tenants and it's trying to figure out what damage came from what, and did the tenant damage this or did this come from the storm damage? So I definitely feel for the tenants the landlords out there who are trying to figure out what to do with their properties.
Well, also uninhabitable is just, it really means you cannot live anywhere in the home. So if there's a situation where just say the front of the home is damaged,
that makes sense.
You can still live there.
You can stay in the back.
You have to give the landlord a reasonable amount of time to fix it.
Yeah.
So you can't just, I don't want to live here anymore.
Yeah.
You have to.
That makes sense.
It has to really just follow the statutes to do it properly.
Okay. So we've obviously gone over quite a bit of things in terms of what the law says and what the statutes cover for landlords and tenants. But what would be your top tips or pieces of advice that you would give if we haven't already covered it for like landlords and tenants? Like, what would you say are, these are things that you should do? I think we kind of talked a little bit about that with the repairs and putting things in writing and stuff like that, right?
Yes. Mm-hmm. So I would say the top piece of advice, read your lease thoroughly. Please
I'm guilty.
Read the lease.
I don't, when I was renting, I hit the high points for sure. Like, if I have to terminate the lease early, what's the penalty? What's the process? The rent and that kind of thing. But
just read everything. I have seen so much crazy stuff in these leases. Like, just read everything. It will take you some time. It is tedious. Just do it, and then I say that for the landlords and the tenants, because especially newer landlords.
Yes.
Do not go to Google and look for a standard lease and then get someone to sign it. Like, at least read over it, customize it to what your property needs. There should not be terms about a pool
if you don't have a pool.
Yeah. So read your lease or, whatever lease you're trying to enforce.
Yeah.
Read it and just make sure you also understand it, landlord. And you're not
you putting terms yourself in there that you don't even understand.
Yeah,
that's
putting
true.
yourself in things that you are not aware of, and just read the lease. That's the top piece of advice I would like to give.
Yeah. Anything else that you think? Obviously, we touched on, what to do in terms of, the storms and things like that. But we didn't really talk about how to avoid maybe some of the issues that we're seeing now in like protecting yourselves for, God forbid, we have another hectic storm season next year or the year after, and it has the same or similar impact as we just saw with Helene and Milton. Are there things that both sides can do to like kind of prepare for this sort of thing?
Yes. So I'll break them down, tenants and then landlords again.
Let's do that.
So for the landlords, review your lease specifically for disaster policies.
Okay.
Some leases have it, some leases don't. But just check your lease to see if it addresses your obligations during or after a natural disaster, just such as, like, I think I briefly talked about it before, like rent abatement, termination of lease, if the property becomes inhabitable, take photos and pictures, videos of any damage.
Definitely.
Immediately.
Yeah. And that's not just for tenants. I mean, homeowners as well. That's the number one thing that I do when I know the storm is getting ready to come. like the day before it hits, I'll
Before
go
and
out.
after.
I will go out and do a whole video. We'll video the whole property. We'll record our fence,
Same.
everything. So that way we've got it before the storm hits.
Right.
Then afterwards, go back out and do the same thing.
Yeah. I mean, it might seem a little tedious, like, ooh, I don't want to do it, but it will benefit you in the long run. So when there is damage, you're able to notify your landlord immediately in writing and pictures.
Right. You've got all the documentation.
And you have it before and after. This will establish, the condition for repairs or potential insurance claims.
Exactly. I was going to say not to keep taking it back outside of landlord tenant, but even with homeowners, can you imagine the causation arguments people would have between Milton and Helene? It's like, well, which storm caused it? And if you didn't take those steps to document between the storms, it was like 2 weeks in between each storms. So if you didn't, the carrier or FEMA, whomever, they could be like, well, how do we know which storm this actually came from and which claim it should go under? Well, here's the video, because I took a video between each accident or each claim or each storm.
Right.
And you can see what the differences were. One storm was more of a water flood, wind-driven rain type of an event. The other one was more wind.
Yes.
So we saw more trees down, more roof damage, fence damages. So one caused a lot of water damage, one caused a lot of wind damage. So it was a little bit easier to identify which one caused which, but you can only do yourself, you could do yourself no harm by doing the videos and the pictures before the storms come.
That's so true. And while we're on the topic of insurance, everyone is not required to get renter's insurance.
Yeah.
But if you do have renter's insurance, please know what it covers. I had a client the other day. He was like, "Oh, I have renter's insurance." When you read the policy, it covered none of his personal items.
Oh gosh, yeah.
And all he had to do was read it.
Yeah.
Or ask
and it's
questions.
probably something he could have added to the policy if he was aware that it didn't cover his personal items.
Yeah. So definitely know what it covers. And just make sure it covers your personal property, because that's what you have.
The main thing that you actually want the policy to protect.
Yes. And know how to file the claim once you have to, file a claim. And then, of course, the last one is the temporary relocation. If the unit does become uninhabitable, just ask the landlord for clarity on their policy, which you probably would know this already if you read over that lease. And seek alternative housing.
Reading the lease.
Yeah, because some landlords do put it in there that I can provide you with alternative housing.
Yeah.
And then under Florida law, you might not owe rent, for those periods where it is uninhabitable.
Right,
so know that as well. Moving over into the landlords, prepare your property in advance.
Yes.
You don't live there, but you need to inspect regularly, maintain the hurricane feature, the hurricane prone features like the roofing and the windows and the storm shutters. Secure outdoor items and so you can prevent more damage during the storms.
Right, because most times the actual structure in the building itself, that is the landlord's responsibility. Securing that, like sandbags and, those kinds of things, that's the landlord's responsibility. So the tenant may obviously assist and go out and get those things, but the landlords need to be coming out and securing their own property.
Yeah, they do. And then, of course, they need to also communicate with the tenants. Just a hurricane preparedness plan, especially some tenants are in homes. They're not in apartments. So if you know that when a storm is coming, your tenant might be responsible to go out and put the shutters on or, tie down certain things that, put that in the lease, just give them a heads up.
That way, let's say you live in Michigan and your home is in Florida, you want to know that your tenant is putting the shutters on like they're supposed to. And if you explicitly put that in your lease, then that's smart.
Yeah. And then also just make sure you have emergency contact numbers and just specific instructions on how to go about or navigate a situation like this.
Yeah.
Another one is understanding repair obligations.
Yeah.
So after a storm, the Florida law generally, of course, requires the landlords to make repairs. And, you know, the landlord needs to prioritize prompt communication with the tenant.
Yeah.
Because now they have nowhere to stay or nowhere to go.
Oh my gosh.
So
I can't imagine the feeling of like, I haven't heard from my landlord and my roof is caved in, you know?
Yeah. So I think it's important. No, I know that it's important for the landlord to have prompt communication about repair timelines and how fast things will, you know, be repaired or just working with the tenant.
Yeah.
I really just think that a lot of these types of things can be resolved with just communication. The next thing is knowing, as a landlord, also knowing what your insurance covers.
I was just about to say that because I remember a situation where a client, their home got damaged and the landlord thought they had a certain kind of coverage. A car actually went through the house and it took out like the front part of the home, and the landlord was like, "Oh, I got insurance. We'll take care of it." And then they didn't have the kind of coverage that would cover that kind of an incident. And of course, the auto insurance only was like $10,000. That wasn't enough. And so this person is literally living with like a gaping hole in their rental home. And the landlord's like, "Oops, I thought I had the coverage and I didn't." And so now we're stuck in this situation where we got to go through a long repair process that we thought would be handled quickly, but now it's going to take some time.
I would probably think that termination of the lease would be, you know, the best
in that circumstance, especially if the repair is just going to go on for a long time. And then also, make sure you have your own, like you touched on the rental coverage. Make sure you have your own coverage, because you don't always know what your landlord has or doesn't have anymore, or they change their terms or insurance. So you just want to try to cover yourself as much as you can.
And renter's insurance is very reasonable, I think.
It's affordable.
Yeah, it's very affordable. So definitely for tenants, I would highly suggest to get the renter's insurance and make sure that it covers your personal items.
Yes.
And then for the landlord, you need to know what your homeowner's insurance covers.
Yes.
And then, of course, provide written notices for the uninhabitable units. If it becomes uninhabitable, you need to document it in writing for the tenants, and then of course, discuss the suspension of rent or lease termination. And then the last thing is plan for rent adjustments.
You got to.
And when I say plan, I mean for your own personal expenses, because I've had some situations where the landlord's house that they live in is gone and their rental property is gone. So, you know, you need to plan. I know it's kind of hard to plan ahead for things like this, but, you know, if, I don't know, you just have to try to be prepared.
Think ahead.
Think ahead.
Wow. Well, this has been some extremely helpful information. We have another comment that said these are good points on alternative housing when the unit is uninhabitable. Never thought about that with my rental agreement. So our listeners are really thankful for this information that you're providing. You're giving them things to think about. But that is the end of our show. And of course, for anybody that's listening, we want them to be able to know how to find you very quickly. Give us the details of your firm, phone number, and any way they can contact you.
Okay, we are Seaward Legal PA. If you would like to give us a call, our number is 727-437-1511. Our website is seaworlegal.com. And then you can also just search SeaWorld Legal on Google or any social media platform and you'll find us.
Awesome. Thank you so much for joining
Thank you
us
for
once
having
again.
me.
I hope you all enjoyed the show. This has been FLA Law live on the radio. And as always, we will see you next Tuesday at 5.